The Supreme Court just dropped an emergency decision that could wipe out gun permits across the country.
Of tougher gun laws, the United States Supreme Court.
People who want to get a handgun permit.
But here's the twist. The Department of Justice isn't opposing it. They're backing it. Right now, 26 states are lining up in support while permit-heavy states are scrambling to hold the line. What happens next could completely reshape how every American exercises their Second Amendment rights. This is the biggest gun rights showdown since the Bruen case, and the fallout has already begun. If you care about your freedom and the future of gun ownership, hit subscribe to Second Amendment Advisor. This is one story you don't want to miss.
Disclaimer.
I'm not a lawyer, and this isn't legal advice. Gun laws are changing fast, and they're different everywhere. Always check with a legal professional and your local laws before making any decisions. The Hawaii permission trap that sparked a national firestorm. To really understand how this case blew up into the biggest Second Amendment showdown since Bruen, you've got to look at what Hawaii did right after that landmark ruling dropped in 2022. The Supreme Court made it crystal clear. States could no longer hide behind may-issue permit systems. That era was over. Gun rights had to be treated like other constitutional rights, with the presumption of freedom, not restrictions. But Hawaii didn't just ignore that ruling. They took it as a challenge. Instead of backing down, Hawaii built something even more extreme. They flipped the entire idea of public carry on its head. Under their new law, you couldn't carry a firearm on private property unless the owner gave you explicit written permission ahead of time. No sign saying guns allowed? Boom, you just broke the law. Silence became a setup, and Hawaii wasn't acting alone. States like California, New York, New Jersey, Maryland, and Massachusetts watched Bruen land, then quietly started building legal workarounds. They didn't repeal permits. They doubled down on them. They didn't expand carry rights. They locked them down even harder. Between 2022 and 2024, those 5 states passed a combined 47 new gun restrictions, with Hawaii leading the charge, writing 14 separate laws to tighten the screws. But Hawaii's version went too far. Even for the liberal Ninth Circuit Court, their law made 99.8% of private property off-limits, unless you could show written permission. Gas stations, parking lots, shopping malls, all banned by default. This wasn't regulation. It was elimination. It turned legal carry into a legal trap. And when lower courts let it stand anyway, the Supreme Court had no choice but to step in. Because what Hawaii was doing wasn't just another gun law, it was a direct challenge to the court's authority. Their entire defense relied on one outdated comparison from the 1800s, a single historical footnote that had nothing to do with permits. But what makes this case truly different from every Second Amendment fight before it is who showed up to push back. The DOJ shock that no one saw coming. What happened next stunned just about everyone in the legal world. The Department of Justice, like the same agency that usually defends strict gun laws in the name of public safety, suddenly flipped the script. Instead of backing Hawaii's permit scheme, they broke ranks. And not quietly either. When the case hit the Supreme Court, the DOJ filed a brief that did the unthinkable. They basically admitted Hawaii's law had no leg to stand on under Bruen. They told the court, flat out, that this wasn't about protecting property. It was a blueprint designed to choke off carry rights using a permission structure that had zero historical support. And they weren't subtle. The DOJ pointed out that property owners already have rights under trespass laws, so why add another layer? The answer was obvious, not safety, but suppression. And then came the real bombshell. The DOJ used the word pretextual 4 times in their brief, legal code for saying Hawaii's arguments were phony, a pretext, a cover-up. But they didn't stop there. For only the 3rd time in 40 years, the federal government actually asked to join oral arguments on the side of gun rights, not against them. That move sent shockwaves through every courtroom in America. State attorneys general picked up the phone. Legal funds redirected resources. Everyone realized the ground was shifting fast, and just when it looked like Hawaii might be standing alone, something massive happened. 26 states stepped into the fight, not to defend Hawaii but to fight against it. They filed formal briefs telling the court this wasn't just a bad law, it was a constitutional disaster waiting to happen. This wasn't just backup, it was a legal ambush. A majority of the country telling the court, we need one standard for gun rights and this law breaks it. Now, before we go further, you need to see exactly how Hawaii set this trap and how easy it was to fall into. How Hawaii flipped permission into a trap. At the heart of the entire case is one sneaky little trick, a complete rewrite of what permission means. In most places, if a property owner doesn't want guns on their land, they have to say so, usually with a sign. That's how it's always worked. Silence means nothing, but Hawaii flipped the default. They said if a property owner didn't explicitly give you written permission ahead of time, you were breaking the law. No guns allowed sign? That wasn't just unclear, it made you a criminal. So imagine this. You're a law-abiding gun owner. You pass background checks, you complete Hawaii's entire permit process, you carry legally, then you walk into a grocery store with no sign posted. Under Hawaii's law, you've just committed a crime. The store owner doesn't have to object, doesn't even need to know. Their silence becomes a legal trap, and lawmakers knew exactly what they were doing. Internal emails show state officials openly discussing how most businesses would never bother posting signs. They admitted it would create a de facto carry ban, and that's what they wanted. The state's own attorney general estimated that less than 0.5% of businesses would post firearms welcome signs. In other words, 99.6% of places would become off-limits by default. This wasn't about keeping people safe. It was about shutting down carry rights. Quietly, and with legal cover, Hawaii tried to flip the Constitution upside down. What Hawaii did wasn't just aggressive. It was the complete opposite of what the Supreme Court said in Bruin. Bruin made it clear, the right to carry is the default, and if a state wants to restrict that right, it better have solid historical backing. But Hawaii didn't just ignore that. They flipped it on its head. Their law made carrying the exception and banning it the rule. And even the Ninth Circuit, on a court not exactly known for gun rights, struggled to justify it. They reached all the way back to the 1860s and found just 2 historical examples to support Hawaii's model. But here's the problem. 3 other federal circuits had already rejected those same examples. That's how weak the foundation was. And here's the part that should make every American pause. If Hawaii can twist the Second Amendment like this, what's stopping other states from doing the same to your First Amendment or Fourth? If government silence can become a ban on carry, what else can they flip? That's exactly what the Supreme Court is being forced to answer right now. And the stakes go far beyond Hawaii. The legal fallout is spreading fast. The moment the Supreme Court agreed to take this case, it stopped being just about one state. Because if the justices strike down Hawaii's law, and all signs say they will, it's going to knock over every other state that followed the same path. States like California, New York, New Jersey, Maryland, Illinois, and Massachusetts built almost identical frameworks. They hoped that if they moved together, the courts wouldn't take them all on at once. But if Hawaii's model falls, that legal shield disappears, and every copycat state gets exposed. And here's where it gets intense. As of right now, 127 lawsuits are sitting in federal courts across the country, all challenging similar post-Bruin restrictions. Not 10, not 50, 127. Lawyers have hit pause. Judges are holding back. States have been stalling for months, hoping the Supreme Court wouldn't step in. That gamble is about to blow up. One ruling could set off a national chain reaction. Once the court hands down its decision, and it's expected any week now, every one of those 127 cases comes roaring back to life. Plaintiffs will immediately push for emergency injunctions. States will scramble to rewrite laws on the fly. Judges will be forced to apply a brand new precedent across the board. And it's already happening, like even before the ruling drops. Back in January 2025, New York quietly stopped enforcing 3 major post-Bruin restrictions after internal memos warned they were legally indefensible. California delayed 2 upcoming permit regulations without explanation. New Jersey's Attorney General instructed prosecutors to use discretion on permit cases, legal code for don't enforce this unless you want a lawsuit. These aren't policy tweaks. These are states retreating because they know what's coming. The Supreme Court's ruling is expected to create a uniform national standard that every state will have to follow, whether they want to or not. The collapse of the permit money machine. Permit systems weren't just about control. They were massive revenue engines, pulling in hundreds of millions annually. In 2023 alone, California collected $47.3 million in permit fees. New York brought in $38.6 million. Illinois, $29.4 million. Across all permit-heavy states, the total crossed $200 million just in government fees. The private sector, even bigger. Required training brought in an estimated $680 million annually. We're talking certificate mills, software vendors, and gun ranges built entirely around state mandates. But when permits go optional, that revenue disappears, and it's already happening. Hawaii's permit division shrank from 47 staff to 19. Applications dropped 78%. New York refunded $6.8 million to over 14,000 people. California stopped collecting $1.2 million monthly after dropping its issuance fee. Illinois and New Jersey project revenue shortfalls of $33 million and $41 million respectively. 3 of the largest carry training companies filed bankruptcy between November 2024 and February 2025, all citing regulatory collapse. Law enforcement caught in the middle. While the financial fallout spreads, law enforcement is stuck in legal limbo, trying to enforce laws that might be days away from being ruled unconstitutional. In January 2025, 19 California sheriffs issued a public statement saying they'd no longer check for carry permits during traffic stops unless another crime was involved. Their reason? They couldn't, in good conscience, enforce something the Supreme Court might strike down any day. That's 19 elected sheriffs refusing to enforce state law, not because they're anti-government, but because they're trying to protect themselves from lawsuits. And they're not alone. A late 2024 survey of 340 police chiefs across 8 states found that 62% had already told their officers to use discretion with permit violations. Translation? Look the other way unless public safety truly demands action. Prosecutors followed suit. From mid-2024 to early 2025, district attorneys in 14 counties dropped over 1,800 pending charges that were based solely on permit paperwork, no other crime involved. Why? Because if the court rules against Hawaii, every one of those convictions becomes a potential civil rights lawsuit, and some of those cases could come with big legal payouts. Gun control groups in panic mode. Gun control groups saw what was coming and went into full crisis response. Everytown held 3 emergency meetings in January 2025. Leaked emails showed staff scrambling to draft post-permit strategies, not acting confident, just trying to limit the damage. The Giffords Law Center shifted $4.2 million away from state lobbying and poured it into federal litigation, not to win, but to slow the loss. The real question, who holds the power? This has become bigger than Hawaii, bigger than permits. It's about who holds the default power, the citizen or the state. The Supreme Court isn't just reviewing a local law, they're deciding whether the right to carry starts with the individual or if it starts only after the government says yes. For years, some states argued that gun rights are special, that it's okay to force people to ask for permission. But Bruin rejected that argument. It said the Second Amendment deserves the same protection as the First and the Fourth. But many states ignored that ruling. Hawaii took it to the extreme, creating a system where you had no right to carry anywhere, unless a business owner handed you a written note saying it was okay. Imagine needing written approval to speak freely in a store, or to stop police from searching your car. That's the level of control Hawaii tried to normalize. The historical test set by Bruin made the standard clear. Historians couldn't find a single valid example of blanket permission requirements on carrying arms. States regulated time and place, but not permission itself. The only close comparison was an 1870 Tennessee law requiring pistol permits, and even that was struck down by Tennessee's own Supreme Court in 1871. Hawaii tried to twist property rights into a loophole. Yes, business owners can say no to guns through trespass law, but that's not the same as requiring written permission before someone even walks in. One approach respects individual rights, the other erases them entirely. This is the moment of truth. This isn't just about permits anymore. It's about drawing the line between freedom and permission, between the citizen and the state. Once the Supreme Court answers that question, the rest will fall into place. But don't expect instant clarity. The rollout will play out state by state, and the chaos will take time to sort through. What permitless carry actually looks like. So what happens if permits disappear? We don't have to guess. Right now, 29 states already allow permitless carry. And between 2010 and 2024, 21 states made the switch. The results? Crime didn't explode. In fact, FBI data showed violent crime dropped 8.2% in constitutional carry states, compared to just 2.1% in states that still require permits. Vermont never required a permit, not in 2024, not in 1924, not ever. And it remains one of the safest states in America. Maine went permitless in 2015, and by 2025, their gun homicide rate dropped to 1.1 per 100,000 people. New Hampshire went permitless in 2017. South Dakota followed in 2019. Neither saw a rise in gun violence. What permitless carry does is cut through red tape for responsible gun owners, while criminals, as always, ignore the rules anyway. What comes next? Each state will handle the change differently. Some will move fast, others will drag their feet until lawsuits force action. Some will keep permits as an option for reciprocity. Training will shift from mandatory government classes to voluntary private education. Just like we don't require civics lessons before you vote, permitless carry means you don't need a license to exercise a right. The Supreme Court won't force one uniform system, but it will create a constitutional baseline every state must respect. Rollout will take time. Expect 18 to 36 months of legal adjustments, new legislation, and court battles. But the direction is now clear. In America, your right to carry doesn't begin at a permit office. It doesn't depend on red tape, and it shouldn't cost you money to exercise a constitutional right. It begins with the citizen, and the Supreme Court is about to make that official. Final message. So here we are, a Supreme Court ready to rewrite the rules, states scrambling to rewrite their laws, and a national permit system running out of time. If you want to stay ahead of this story and know exactly how it will affect your state, hit that subscribe button and turn on notifications right now. You don't want to miss what happens next. And let us know in the comments. Is your state preparing, resisting, or stalling? The fallout is already underway. This is Second Amendment Advisor, and we're just getting started.